A year ago, I started doing webinars. If y'all are on my email list, I'm sorry. If you're not, you probably will be because I'll get your email from somewhere. It's a reminder here how difficult it is to speak in front of people and not in front of a computer screen. It's much easier to not have to see reactions, smiles, smirks, eating breakfast on your phone. So forgive me, I'm more scared than y'all are. So let's get through this. I'm supposed to hit F5. Boom, there we go. They also say that when you're speaking in front of people, you're supposed to show your chest, your stomach, because that makes you more believable. So I'm going to do this for most of the time. Plus, I'm antsy and can't move. So my goal, my job here is to talk to you all about the Ask at Trial, which is pretty fun. It's pretty awesome. My favorite thing to do as a kid was go to flea markets with my dad and try to hustle people for stuff, like over $1. If you know me, that still goes on, even now. One of my lawyers wanted a raise, and we had fun on that recently. But for the ask, I think it's impossible to do this without some sort of perspective. And it's weird to talk about money with strangers, although we all kind of know each other here. So let me just, as a show of hands, who here remembers 1981? I don't, I'm going to be honest. Who here was born in 1981 or before? All right, sorry to make y'all do that. In 1981, Charles and Diana got married. In 1981, the Rolling Stones were touring the United States, and they were really popular. That's Sugar Ray Leonard. He had just become heavyweight champ. Larry Bird, inside, smoking a cigar after winning winning the NBA championship. Ronald Reagan was Man of the Year. Raiders of the Lost Ark had just come out. And IBM was becoming a thing. Here's where all you people that raise your hand are going to feel bad. I'm sorry about this, to some degree. We all know what happened. They got divorced. One of them passed away, but it's been decades. I was in the mall the other day, and someone asked, there was a Rolling Stone song, and no one knew who that was. All the little kids, which aren't that little, no idea. Sugar Ray Leonard retired after this fight for the first time, like any good boxer. Smoking indoors was definitely a thing, and there was no three-point line. Stephen Curry wouldn't be shooting threes back then. I'll say this from personal experience. People, even if you're on that side of the political spectrum, the Reaganites, most people, a good significant chunk of voters, don't remember Ronald Reagan. I don't. Raiders of the Lost Ark, when people went and saw that, it was $2.87 to get a ticket on average in the United States. I don't need to tell y'all what the price is now. It's more. Does anybody know how many computers IBM was selling in 1981? Anybody? One personal home computer. That's it. One. The reason I say this is because 40 years has passed since all of this, and 40 years seems like a long time, but it's really not. We have clients, probably all of us, who are going to be suffering, have injuries, be in pain for the next 40 years. I mean, think about it. If you have a 40-year-old client with a permanent injury, that client, or hardware, whatever it is, that client's going to be suffering for 40 years. And it's your job at some point during the trial to give perspective to the jury and say, this is all the crap that happens in 40 years. And we have to give that perspective in terms of time and money because they seem to go hand in hand. I can see Kelly Casey telling me never turn my back on the audience, by the way, as I just did that. All right, so asking for money is truly about perspective, and everybody has different perspectives on money. We have a very warped sense, and I'm going to speak for all of us. We have a really, really warped sense of money. How many times you heard this last 2 days? Yeah, I settled that case for $25,000. Yeah, it was only a $100,000 policy. That's all I got. Yeah, it was $1 million settlement, but, I wish there was more coverage. I literally heard this yesterday. Somebody said, yeah, I think I'm going to get all 6, but that's just not enough. Y'all heard stuff like that, right? Most people don't have those kind of conversations. $25,000 is, and this is a technical legal term, is a shit ton of money. It's like a ton of money. $100,000 is more than most people make. $1 million is more than most people will ever have in their entire lifetime. Think about that. And I'm not saying we do anything wrong by having a warped sense of money. I mean, it kind of comes with the territory. But some people consider money as the root of all evil. Some people consider money as a necessary thing I have to have. Some people, maybe some of us, maybe some people we know, value money too highly, if that's possible. I don't know. So all the different people in this room and eventually our jurors are going to have different perspectives on money. If you're in a sorority or fraternity, or if you're on online dating, the three things you usually don't talk about right away are religion, sex, and money, right? We have to walk into a courtroom and you're asking about one of those three things. You're going to ask for money, and you have to know people's perspectives on money to be able to do that. Andy Cash yesterday, when he was holding up his sheet of notes from the trial at this point a year and a half ago, whatever it's been, I guess more than that, whatever the math is there, that's the biggest thing that's changed my practice from the first trial I ever had to the last one, is actually writing down and keeping and studying what the jurors said during jury selection. Did juror number 5 say money is the root of all evil? Did juror number 9 say, no, I love money, I want more of it? You know, all those kind of things. You have to know people's perspectives. You also find that money is related to work. For most people, money is related to work. And that's why you hear things like, well, that person doesn't make a lot of money because they don't work hard. Or that person has a lot of money because they really grind it out. Whether that's right or wrong, that's the general perspective on money. Money, it can be good, can be bad, but you got to know from your jurors. So this is an impossible talk to give without talking about jury selection. And I'm going to try to not make this about jury selection, but it's impossible not to talk about it. In jury selection, I've listed some ideas of things that you need to do. And the first bullet point is the one I'll spend the most time on, or at least highlight. The goal really is not to anchor. So when this one day gets looked at by a GTLA member or whatever they are, or gets used later, like my webinars have over the last year. Truly, when you talk about money, I don't think the number one goal is to anchor. It's really not. It's to find out what your audience wants. My perspective on jury selection is that it's the best possible focus group you can have. How many of y'all have used focus groups? Leave your hand up if you think they're way too expensive. Yeah, so do we have a focus group sponsor? I apologize. But anyway, the way I look at jury selection, I heard, I think it was Lloyd Bell years ago talk about this here in this room, that instead of asking 9 different questions to make to be like a beautiful mind with that guy with all the strings connecting dots and trying to figure out, he's originally from New Jersey. He went to school in South Carolina. He then moved to Georgia. He's got this on his bumper sticker. He worked at Fox News, which throws everybody off. And now he has his own business. So therefore, he must think this about money. That's me, by the way. And I have no idea what that tells anybody. So my belief is that you can say to jurors in jury selection, tell me how to try my case. It's the best, cheapest focus group. So in terms of money, instead of a question like, do you believe in caps? I don't know. Jurors don't even know what that is, by the way, I don't think. A cap on what? Or a question like, do you think there's a higher burden that should be placed to prove pain and suffering damages as opposed to medical bills? Who's asked that question? I have. I mean, I've asked that question. I guess I'm the only one in the room, but I've asked that question. What I now ask is, if I prove to you that my client has suffered pain, which to me means physically, and has suffered suffering, which to me means mental suffering, if I prove to you that there was pain and suffering, how do I show you how much it's worth? Like literally, how do I do that? And I look at the juror, I look at Donovan Potter, I'm like, Juror Potter, dude, how do I show you that my client, how much their pain and suffering is worth? 9 times out of 10, the juror's gonna say, I don't know. That's a good answer, that's fine. Sometimes the jurors say something you want. They're like, oh, I don't know, give me a lump sum. And you're like, yeah. Mike Goldberg's like, yes, lump sum, that's my wheelhouse, 10 times, right? Some people will say per diem. And usually in my mind that I get scared. I'm like, I don't want to give a per diem. But I need to know if that juror wants a per diem. So what I'm trying to do in jury selection is literally find out how to try my case. And all the focus groups in the world before trial are great, but they're not the 12, 13, however many people are going to end up in that box. So I want to know what those people specifically want to see, how they want me to prove and try my case. And if you have those answers, if you know juror number 7, 9, 14 want a per diem, juror number 1, 2, and 19, they want a lump sum, all the other jurors, they don't give a crap, well, then I can ignore all those other jurors, and I focus on a per diem and I focus on a lump sum. I may want to do, and we'll talk about it later, I may want to do a wanted poster, because I think it's a good case for it. Well, if a juror goes, I don't know, just tell me a lump sum. If all the jurors say that, I'm not going to give a wanted poster. I'm going to give them what they want. It's like, what is that Mel Gibson movie, What Women Want or whatever? I don't know if that's socially appropriate anymore. But if you know what the juror wants, and if you can figure that out, then you can give it to them. And then it's not on the lawyer to come up with some magical, perfect way to try your case. You do what they tell you. You know, in dating, if the other person says, I really like Italian food and I like to be picked up and it's important to me that you walk to the door, when you go to the date, are you not going to do that stuff? You're going to honk the horn, go to Mexican, and then, drop the person off on the curb on the way home? No. You're going to do what the person wants. So if we can figure out what jurors want, then we just need to execute that. Which means in the planning stage, you have to be able to do all the different things. You may hate the per diem. You can already tell my thoughts usually on it. You may hate doing a per diem, but you have to be able to. In my office, for example, I think we spend way too much time on the liability aspect, who's at fault, because that's easy, that's fun, that's an easier thing to figure out. I don't think, in general, we spend enough time trying to figure out how much the case is worth and how we're going to prove damages. And if any of y'all fall into that trap sometimes, especially in automobile cases, you should be able to figure out who's at fault, or at least know your risk. The majority of the case should be spent on proving your damages and later asking for money. In opening, I like to give my number. It's not a secret. This is what I want, jury. I want $1 million. This is a $1 million case. That's usually what I'll say, if that's what it is. I'm going to give them hard numbers so it's not the first time they're ever hearing it. I'm going to give you your past medicals. I'm going to give the future. I'm going to give an impairment rating if I know it. And I'm going to tell the defense, I'm going to tell the jury, here's what we're eventually going to ask for. And I've hopefully done that during jury selection as well. So they've heard my number at least twice before they even know much about the case. All right, I'm trying to reach a broad range of people in here. So I want to just go through the different types of ways to do the ask. And the first way is the easiest way. It's the lump sum or range or a multiple of medical bills. I don't know if I should say this, but I will. Multiplying medical bills for pain and suffering makes no sense to me. If someone has an answer to this, I would love to hear it, because we do it all the time. I mean, I had a conversation with an insurance adjuster, and I'm playing by their rules trying to settle this case. And I'm like, look, it's 3 times the medicals. Well, that doesn't mean anything. If someone dies on impact in a tractor-trailer crash, they have no medical bills. You can't multiply medical bills there. If somebody needs some crazy surgery and they can't get it, and it's really expensive, but they can't get it, well, there's no multiple. What are you multiplying? So to me, multiplying medical bills for pain and suffering can make some sense, but it's not the end-all be-all. I think, and I was just talking to Shay Shulman about this, I think the way to ask for a lump sum is you have to be the expert in the room. You have to have the jury's credibility, and the jury has to believe you. And that starts from the moment you walk in the courtroom to knowing the bailiff's name, knowing the court reporter, acting like that is your courtroom and you're there every single day. Jurors have no idea. They have no idea if you've never been tried a case in Clayton County or whatever. But you have to show that you are. And if you're the expert in the courtroom, then the jury's going to look to you for advice. And at the end of the day, if you're confident, you believe your number, you trust your number, and you can stand there with a straight face and not make everybody blush and say your number, I think you have a really good chance of getting it. My fear with lump sum is that the jury's automatically going to think I'm shooting way too high. Right? Does anybody else have that fear? If I say my whole number, they're obviously going to think it's overblown. So I try to do 2 things to avoid that. The first thing, as I tell the jury, I'm not trying to split the baby here. This is a real number. I could ask for way more. I'm choosing not to. My number is real. This isn't a game of this or that and what you're going to do in the middle. I'm planning on you, jury, to give me every single dollar that I'm asking for, because I would never come into court and ask you for money that I don't believe in. I'm not going to do that. Second thing I do is tell them don't ask or don't ever award above a certain amount of money.
So I had a case where I asked between $1.5 and $2 million. I said, that's what I think the range is. Medical bills were $105,000. Wasn't doing a multiple there. So I just said it. I didn't have a great rationale. I just thought the jury absolutely hated the defendants, and they did. If you know me, I'm kind of good at making people angry sometimes, people frustrated. It's a skill that I have outside of the courtroom as well. So that's something I think juries award tons of money if they're very angry, and I say Michelle King laughing. If they're very angry, they award money, and if they feel very bad for your client, badly for your client, they'll award money. You put those two things together, you have a chance at what the defense will call a runaway verdict, which I will typically call just bad lawyering resulting in a large verdict. So in this case, I asked for $1.5 to $2 million, and I said, no matter what, even if you think I'm wrong, no matter what, don't ever, ever, ever award more than $2.5 million. Don't do it. Now the transition I think here is my client thinks his case is worth $1 billion. That guy got shot. I don't know what that's like. I've never been shot. None of the jurors had been. That guy has a right to ask for every single dollar that he can imagine because he's the only one that's been through it. But, and I look right at him and I say, and I've talked to him about this, his case as a business, his business case is not worth more than $2.5 million, so do not do that. We asked for 1.5 to 2, we got $1.73 million. Then I sit up at night and go, should I have asked for more? Should I have done that? No, I think I got the right number. The last thing I'll mention about this, two things I guess. Use sale techniques. The reason you go to Walmart and it's $9.99 instead of $100 or $10 or whatever it is. Use exact numbers. That promotes that you're being specific. Don't just throw up $1 million. Say I want $998.97. That puts significance on there. It's not a made-up number. And the last thing is I think you can use movement to show the jury how reasonable you are being. I'm checking my time here. So for example, over here, this is the value of soft tissue cases. Somebody gets rear-ended. Maybe they don't go to the doctor right away. 2 days later, they feel pain. And then they go to a chiropractor after, 2 or 3 sessions. They feel great. That's awesome. That's the value. This right here, this is the value of that case. I walked out of a courtroom once into the hallway and yelled. This is a wrongful death case, a traumatic brain injury. This is what happens when someone's every day of their life, every minute is affected. This is how much money that is. I'm only asking you, here's the warped sense of money, I'm only asking you, jury, for $1.5 to $2 million. That's what I'm asking you for. And then you can walk it off and say, look, these are all the things that my client's lucky enough not to have, but this is how bad it is. But it's still over there. So you're showing the jury that, hey, look, there's a number. You don't even have to say what it is, but there's a number down the line that I'm not asking you for because I'm reasonable. The per diem. Who became a lawyer so they could do math? Yeah, all right. Who here, though, can do percentages on a 40%, 33%? Yeah, okay. So the per diem problem is that there's too many numbers often. Your client was injured from the time of, let's say, the motor vehicle crash, then to the surgery, and then they felt better, but they had a crappy recovery, but then they feel even better. It's like, what are you doing, 4 different per diems? I can't do that math. I'm just not going to. So what I try to do with a per diem, anytime, first of all, is show your math. You'd be like a second grade teacher. Show the math for everyone. Make sure you're right. Jeb Butler told me years ago, and this is a smart thing. You write in pencil on your piece of paper really lightly, and then when you're going to do it with a marker, just go over your marker or go over your pencil. That way you can't screw it up. Jeb has the worst handwriting in the world, by the way, but it's not as bad as mine. When I'm talking about a per diem, I'm trying to talk directly, that's the Alfred, I'm trying to talk directly to the person in the house that budgets. So if I know my jury notes, juror number 17 is the household budgeter, the person who budgets, I'm gonna not walk as close to you so it doesn't make that noise, but I'm talking directly to you the whole time when I'm doing a per diem. I'm spotting that person. Hey, if you're the person in the house who does the budget, if you're the the planner in your business, if you're the person in charge of money, I'm going to talk directly to you, directly to you. So I think that's important because you got to identify the person who's the math person, the per diem person in your jury if you're going to do this. I like to combine it with the lump sum, and magically, somehow my per diems usually equal my lump sum. It's this crazy thing. But whether you do the math starting with your lump sum and working backwards to the per diem, or the per diem and then projecting out a lump sum, it has to make sense. It has to make sense. And you have to be able to have a reasonable basis for those numbers. Again, money is related to work. Money is related to work. So how do most people value their time? Maybe not some of us, maybe some of us do this, but defense lawyers, most people value their time by how much time they spent, hourly rate. So if you can use hourly rates of work, defense experts, every trial I don't know about the lawyers you guys go against, but every single trial I'm against the best lawyers in whatever jurisdiction I'm in. These are the best lawyers money can buy in Atlanta. I'm trying to build up the bar for the defense case, but I'm also trying to say how damn expensive they are, So I think if you can use a number that the defense has presented, they're willing to spend $500 an hour to not pay my client damages, the Barry Jeffries, they're willing to pay Barry Jeffries whatever he makes nowadays to fly in his plane and tell us that, my guy didn't need surgery even though he's a radiologist. If they're willing to do that, well, then it seems like $500 is a good hourly rate to give to my client. My client doesn't live 8 hours a day. He lives 24 hours a day, and he's in pain all 24. So I'm taking that money, or that number, and I'm multiplying by every single hour and every single day. If you can also use minimum wage is an easy one. It's also a very reasonable one. If minimum wage is a low number, I think that's a fact. But if you are using minimum wage, you can't be more reasonable than that. And remember to tell jurors that when somebody gets up out of bed and goes to work, it was worth it for them. They made a conscious decision to get up out of bed and go to work and get paid. It's the bargain of labor for pay. When your client's driving down the road and gets creamed by a truck, there was no bargain. So your client deserves more because your client didn't make that choice, didn't have that freedom or that free will. I have gone back and forth on this. Chris Stewart actually was the person who I stole this from at some point. But on cases where, I had a case with no medical bills. It was a hit and run in Fulton County. And I tried the case. We got $400,000. There was $3,000. There was one ambulance ride. But there were no medical bills. And I didn't know what to do. I didn't know how to justify this in any way. So I looked at the pattern charge for pain and suffering. And I stressed to the jury that I thought they needed to award money on every single line. And remember, the pattern charge is not an exhaustive list. The pattern charge is just an idea of what the jury can consider. That's what the judge says. So in cases, especially probably smaller cases, where you are worried the jury is not going to take it seriously, you get to blow up the pattern charge and say, these are the elements the judge is going to tell you that you may consider. Maybe you have some more that you can share with the jury. But you need to you jury, need to give an award for every single line item. Every single line item. It kind of goes into per diem world where there's a lot of numbers. But if that's what you're trying to show, that there needs to be a lot of numbers, this is an effective way to do that. I mentioned the help wanted ad. Harvey versus Williams is the case that authorized it most recently. Anybody ever used the help wanted ad? Yeah, for those of you all who don't know, the help wanted ad is you're applying for a job and you're looking at the job descriptions, the duties, and it's how much do you want to get paid for this job? The nice part is it does not violate if you do it correctly in the right verbiage and read the case, you won't violate the golden rule. But you're telling the jury, here's this job. Your job is to be driving to work and get crashed into by a truck, to have to go to the doctors for months and months, have to get physical therapy, injections, radiofrequency ablations, a surgery, recovery, miss work, the whole story. That's your job post. How much is this job worth? Because that's what that's your client's job now. Client lost the ability to work. They lost the ability to work, and now they need to be compensated. And that compensated word is something I use a lot at trial. It's compensation, compensation, compensation. I'm using the word money with you guys, but compensation is the word I keep going back to. So, how much should someone be compensated for this job? Who would take this job? Well, again, my client didn't have a choice, but what's the number? And I think this is an effective way, if you want, for people to look at hourly rates and wages and try to come up with a number. This works really well in conjunction with a per diem. This works really well in conjunction with a per diem. Who's read the book? I'm going to ask Bruce Berger because he's read every book. Where's Bruce? Bruce, what's the book about making the case all or nothing? It's in context of soft tissue cases, but I can't. Anybody? There's a book. There we go. Thank you so much. Who's read Polarizing the Case? I couldn't think of it. All right. I'm going to give a quick synopsis here, and y'all can correct me if I'm wrong. But the idea of polarizing the case is to make the case extremely polarized, to give, at the end, you have an all or nothing choice. And this goes back to that splitting the baby concept of, I want the jury to award my number. I don't want them to give the discount because they think I'm just naturally asking too much because I'm a sleazy, greedy plaintiff's lawyer. I mean, that's what these people generally think of us. But hopefully by the end of the trial, they've shown that we're the most honest, most candid, most reasonable people, and they trust us. And then we've exceeded their expectations, and they feel like they've learned something. What I want to make the case about is, and I'll use the phrase from the book, whether the client is a liar, a cheater, and a fraud. Liar, cheater, and fraud. If your client says, I didn't cause the crash, and they say, well, yeah, you did, well, they're saying your client's a liar. If they're saying that your client's not really hurt, but asking for money, he's trying to cheat the system. And if the defense says that your client is coming to court and asking for an unreasonable amount of money and trying to take advantage of those poor jurors who are pulled out of work, they're essentially committing fraud. So the case isn't about medical bills. The case isn't about anything. What the case actually boils down to is the client a liar, a cheater, and a fraud? And if you do that, and I've done this before, I remember the first time I did it in a trial, I was scared because the result is you ask for all or nothing. And the line I use is if my client is a liar and cheater and a fraud, I'm sorry. Send him or her out of here with $0. Sweat. Your client's like, you better be right. And I'm like, well, you better not be a liar, and cheater, and fraud. And if I prove that you're a good person, a normal human who's not lying, cheating, and fraud, and committing fraud, I should win. And this goes hand in hand a lot of times with a big board where you have two sides of the board. And on one side, you have your client. This is why friends, family, loved ones are so important for damages witnesses. So you have your client, husband, sister, child, coworker, friend from church, doctor, surgeon. On the other side, you have Barry Jeffries. I don't know why I'm using him today, but you have him or somebody. And I think the sell is to the jury. The simple answer is usually the right one. If my client's a liar and a cheater and a fraud, then either all these people are liars, cheaters, and frauds, or that dude is. That dude. The one who's getting paid, the only one who's getting paid in this case. The only one who testifies for State Farm or whatever, hundreds of times. What it does, and you don't need to use that specific strategy, but what my goal is I want all or I want nothing. And if you do that, and if you have the, it's not courage, if you have the, I don't know what the word is, if you're crazy enough to do that, I think you're going to get, and you have the right clients. I mean, you got to have good clients. If you like the other, we were just talking about this. If you like the other person's client, the other side's client better than yours, you should settle that case. Don't try that. But if you have a client that you like, or that you think a jury will like, or that's just honest, reasonable, a good person, I think the answer is to go all or nothing. I firmly believe that. My heart is racing just thinking about that. All right, the last thing I'll cover is just some other random points. And I say this to jurors and I'll say it to y'all, most of the people in this room have been doing this longer than me or smarter than me. I have no right answers here. I say to the jurors, ladies and gentlemen, I'm jealous of you and I'm overwhelmed for you. I'm jealous of you because you get to pick who's right and wrong. That's the easy part. You get to say, who's the winner? But we know a winner with a $1,000 verdict in $1 million case is not a winner. And I tell them I feel overwhelmed for you because you got to figure out, is it per diem, lump sum, wanted out? You got to figure out the number. And you have to put a number that you're going to live with for the rest of your life. Hopefully you don't sit up at night, jury, thinking you got it wrong and my client has all those medical bills for the rest of their life and you didn't give them to them. But anyway, so what I guess my message to y'all is there is absolutely no perfect way to do this. There's no perfect way. So if you know of a different way, please email me. I'd love to hear it. I mean, seriously. If something has worked for you, hasn't worked for you, share it with everybody. I mean, this group of people, and who's ever watching and not asleep at their computer, we are the ones that are setting the numbers and the benchmarks for this state. So if we can help each other do those numbers and talk about our failures, talk about the things that didn't work. The last trial I had was November of 2019. I lost. And I could probably tell you a million things I would have done differently. And part of that was the ask. As soon as they put their pencils down, I should have said, meaning stopped writing how much I wanted, I should have done something differently. And I think if we can all say to ourselves, there's no perfect way, especially because we're relying on the jurors are going to be the ones who tell us the perfect way to try our case, I think we'll succeed. With COVID, and I don't know if anybody's mentioned this, I apologize if I'm stealing somebody's thunder later, we all have a common story now, at least a lot of us do. The average juror's been out of work, they're worried about finances, they understand the value of the dollar, that's my take on it. They understand the value of a dollar more. Whether you have people who say the stimulus check was too little, too late, not enough, I like those jurors. Or the people who say, the stimulus check was unneeded, people should plan for that, they should have a rainy day fund, that's fine too, those so-called conservative jurors. Well, if you can show that the defendant violated those conservative morals, those conservative values, conservative jurors, whatever that means, will award a ton of money if you show that their values have been violated. But you got to ask what their values are in jury selection. I mentioned the cost-value proposition, that something costs more if it's done onto you as opposed to you choose to do it in free will. I like to challenge the defendant, just because I like to challenge people at things. I like to challenge the defendant on what their number is from opening. How much are they going to ask? And this is especially helpful in admitted liability cases, because if they admit liability and admit they were negligent, they got to usually give you a number. And if they don't, I think they look stupid. And the last thing I'll leave here, the last thing I'll say is, I think when you are doing an ask, the most important thing is to rely on those friends, family, coworkers, loved ones who shared the story at trial. Go sit in the jury or go sit in the witness box and say, you remember when Kathy from church came here and said that Susan can't sing in the choir anymore. Go, I don't know, bring in a basketball and say, hey, my client loved basketball. He hasn't been able to play in 5 years. It is show and tell. And I'll say this as one of the younger people in the room. I have the attention span of that, like literally that time period. That was my attention span. So if you're not making your closing interactive, if you're not moving, if you're not showing stuff, what's the average TikTok video time? I don't know. If I see something on Twitter and it's more than the character limit, it says 1/, it means I'm supposed to read multiple things, I'm not reading that. So these are your jurors. We all grew up with phones in our hands, knowing information. I have a game I play with some of my friends where for like a weekend, we won't Google. You have that song stuck in your head and you're like, I can't remember what it is. You know how terrible it is nowadays to be like, I can Google the answer, but I'm not going to. We're going to sit around for 3 days and not answer and think about it, and hopefully. Jurors are doing that. They're Googling their phone. They're figuring out the answers. They're saying, hey, what is multiples of medical bills? They're doing all that stuff. So I think you need to address that in the room. And I really liked Andy Cash's comment yesterday about tell the jurors that if someone is doing something that violates the rules, they need to speak up. You need to, though, know who that person is. Who is your hall monitor? Who's the narc in the room? And you got to be able to identify that person so that way you can speak to, no offense, Xavier, speak to the narc and be like, hey, man, you see somebody doing something wrong. Yeah, he's not the narc. But you have to be able to do that. So the takeaways hopefully are there's no magic answer. These are really helpful takeaways. There's no magic answer. Be confident in what you do, and the best way to be confident in what you do is be the most prepared person in the room. Make sure your numbers make sense, they have perspective, and they relate generally to work, the time value of money. And the last thing is, I think, give the jury an all or nothing proposition. Give the jury an all or nothing proposition. Jurors shouldn't be splitting the baby. Either the person is injured or they're not, and they're entitled to compensation or they're not. Your number's right or it's not. It's scary as all, but I think that will increase the numbers in this room. I also think when we have the better case, which hopefully the case you're trying is the better case, when that's us, there will be no other option but for us to win. There'll be no other option. All right. Thank you all for your time.